I guess we'll start with the state on the motion to reconsider the order setting time for speedy trial. That is also somewhat related to the second motion to stay proceedings. It was filed July 25, 2023. Why don't you go, Mr. Thompson? Oh, no, Ms. Beatty.
Thank you, Your Honor.
Thank you.
Your Honor, we're asking the court to reconsider its order, wherein the court issued a limited tolling period, I guess, or stay, specifically for the purposes of extending the speedy trial period by 37 days. And we filed that motion mainly because we're just concerned about the record in this case, and we're concerned that where Mr. Kohberger has essentially stipulated to there being good cause under the statutory speedy trial statute, we're concerned that should he try to invoke speedy trial later, and should the state disagree with that it could create a very genuine issue to be litigated and possibly on appeal. Now, in the defense's reply brief, their response basically seems to be, well, he didn't waive his constitutional right to a speedy trial. And the state didn't argue his constitutional right to a speedy trial or bring that up because we don't think that there's enough there at this point. That's not to say that if the court were to apply that analysis, it would necessarily come to one conclusion or another, but that was the area of concern for the state, is the statutory speedy trial. And the statutory speedy trial issue is under Idaho Code 1935-01, which provides that a defendant whose trial has not been postponed upon his own application, that their case can be dismissed if they have brought to trial within 6 months. Well, what we had in this case is the defendant filed his initial motion to stay, basically saying, I intend to try to get this indictment dismissed. I don't know how yet, but if the court could just issue a stay and give me some time to figure it out under Idaho Code 2-213, then I'll have time to review the materials and find a way to attack this indictment. That's a litigation strategy. So if the court's response to that litigation strategy was to issue an order stating, well, this statute doesn't provide a basis, but I'm just going to extend trial by 37 days, our concern is that should the trial then get continued based upon the defendant's statement on the record that he agrees that there's good cause, that could really create some issues. It should also concern the court that the defense doesn't really argue the statutory speedy trial issue in the brief. They just say, well, he didn't waive his constitutional right. And that should concern the court as well. Are they agreeing that he's potentially going to be waiving his right or creating this issue down the road if the trial gets continued? I think it's messy, and that's a concern as well. The other reason that we'd really like the court to reconsider this order is that this very short-term continuance of 30 days used as a tool to give them more time to engage in litigation strategies, it makes it very difficult to have some predictability for the folks who will be testifying at trial, and more importantly, who will be testifying at trial and who will be under subpoena for an extended period of time. If we're telling them, hey, we have trial set on October 2nd, but hey, it might be moved another 6 weeks, so basically block out the next 12 weeks of your lives. And, that puts them in a bind. It certainly puts the court in a bind when it comes to trying to figure out how we're going to bring in a very large number of jurors if we're using this as a tool either once or maybe potentially more down the road. I'm not sure. And I think finally, and this is, I guess, the larger concern is the victims in this case. I certainly wouldn't want to put them on a roller coaster where we have short-term continuances of a trial where we get right up to the date and then it's, okay, well, we're going to move it, but it has to be done within the next 37 days. Because that psychologically, emotionally, and travel arrangements-wise, that is a very difficult position to put these folks in, especially folks who are loved ones of the victims who would be very difficult for them. So we would ask the court to take that into account as well, but really primarily the speedy trial issue and the potential for needless litigation down the road, potentially appellate issues. We would just ask the court to keep trial set on October 2nd, and only if the defendant waives speedy should the court move that trial date. We would ask the court to reconsider its order. Thank you, Your Honor.
Thank you. My understanding is that the defense wants to keep it at October 2nd. So I'm not going to kind of piecemeal it along the way.
Thank you, Your Honor.
I mean, the only reason I granted that in the first place is because they do have a right to get the grand jury transcripts and materials. They didn't have it yet, so that was the only way I figured we could do that to let them go through that material, which apparently they now have. So, all right. Who's arguing this one?
Mr. Watson.
Okay, Mr. Watson.
Okay, so we obviously differ a little bit as to whether or not we found anything off with the way that the grand jury went in this particular case. And I don't think the state probably wants to move it into the nitty-gritty on that on the record, so I'll just correct the record in that we disagreed when we said that we needed to do some sort of a fishing expedition. We believe that we'd already brought to the court reasons why that statement could be issued. My understanding of the state's motion to reconsider is essentially saying there's something wrong with this order. My response was there's nothing wrong with the order. There's nothing wrong with saying that there's essentially a pause on the right to speedy trial. Now the state says, well, what about the statute? Well, that's a different area of litigation. And we can start litigating it now, but it doesn't seem right. Nobody has filed a motion to dismiss the case. This court hasn't even moved the trial date. And so if the question is simply, does the order for stay that the court issued, which essentially is sort of a speedy trial has been moved for however many days, is that going to create some kind of litigation down the line? I don't know, even if the court somehow took it back, that would necessarily change anything, especially given our current circumstances. And I think, as the court's noted, nothing's actually changed in terms of when the trial occurs or anything else. And so, from our perspective, Your Honor, I guess we should just say, I don't think this is right for the court to concern itself with what does that mean in terms of statutory arrest and speedy trial. Is that something that we're going to have to litigate down the road? Maybe, but I don't know if it makes a whole lot of sense for us to get into that right now. As for the rest of the concerns the state has, I mean, right now, nobody is saying that the parties are going to be ready to go. So, if somebody at some point does that, then the court will deal with it. So again, I would say a lot of these are hammering concerns that we're hearing. While understandable, I just don't think there's much the court can do at this point. Okay? Thank you.
Well, 6 weeks away. I mean, we're all on bus. It's really challenging, no doubt about it. Everybody's ready for it. Great. Okay, any response?
Your Honor, and I would just, I think just for, if nobody intends to utilize this order, I guess I don't see the harm in just rescinding it, so that we have some predictability as we're planning ahead. We've subpoenaed many of our witnesses. We're looking at making travel arrangements that would give us some predictability. If nobody intends to utilize this order anyway, it seems like it would be a no harm, no foul situation to just withdraw it respectfully. Thank you, Your Honor.
Thank you. All right, before we finish that discussion, I think we should just go to the motion to stay, the second motion to stay, and I think you're going to argue that, Ms. Taylor?
I am, Your Honor.
All right.
Your Honor, I am going to be as intentionally vague as I can. This motion to stay is grounded in Idaho Code 2213. This is a very narrow look and something that would justify the court staying proceedings while the court looked into it further. This has to do with juries, a trial jury or a grand jury. In our circumstance, we're talking about the grand jury. We're looking at if there was irregularity in how that grand jury ended up being the ones that heard the case. We are looking at the way the panel was convened, how the individual jurors ended up being brought in. Was it a public setting? Was it a public polling or calling of these grand jurors? And were these jurors people that had not sat on other juries in that same county. Your Honor, one of the big areas that we recommend the court stay proceedings and look into is the impact on the number of jurors that were called. The number of jurors that should be brought into a jury, according to the statute, is going to be dictated by court order. In this particular case, Judge Gaskell, I believe, maybe Your Honor, issued the order for 45 jurors to be brought in. 32 were brought in. We don't know why. I can't find any record that tells me why that happened. But that's quite a few shorter than the court ordered. And I think the court should stay proceedings and look into that. That matters. That matters because of things that happened within the grand jury. I'm not going to go into those now. Those are things that will become, if we can get an evidentiary hearing, we'll talk about those things. Those are also things we'll talk about when we challenge the grand jury indictment itself. But they matter. There's a reason a court orders 45 grand jurors in to appear to be chosen or selected to be the seated grand jurors in a case. And that didn't happen this time, and we don't know why. There are irregularities on the face of the juror questionnaires. There are some that don't indicate the juror number, the panel number, the wheel number. Those all have to have something to do with the public selection of the grand jurors or the calling and the seating or the list that's brought about to choose those jurors from. I don't know why there would be differences on the face of those grand juror questionnaires in that bit of information. Some had all of it, some had some of it, and one had none of it, including a juror number. Some of those people sat on the grand jury that heard the case. That is an irregularity, and one that we should have an evidentiary hearing and understand if this was a properly convened grand jury to hear this case. Additionally, there are areas that have to be questioned of a potential juror. There are criteria that in any grand juror has to meet. Some are the ability to read and speak English. Some are to not have a felony conviction that prohibited one from serving on a grand jury. There were irregularities on the face of those documents as well. The court should stay the proceedings and allow an evidentiary hearing to determine what, if any, impact those had on the grand jury indictment. There is another issue that was part of the sealed affidavit in the first motion to stay, and there are still questions about what impact, if any, that had on the seating of this grand jury. Your Honor, without going into the exact examples of things, which I think constitutes an evidentiary hearing, we're asking the court to issue a stay in this case and allow us to have an evidentiary hearing and go into those issues more fully.
Your Honor, the Uniform Jury Selection and Service Act really just governs the process utilized by the court in bringing in a jury, in maintaining juror roles, and in regulating the court's processes. The Act sets forth some pretty specific criteria, but there's a lot of allegations that have been raised by the defense that don't fall anywhere within the Act. One of the things that they addressed were allegations of potential juror bias against the defendant. And I think that's what's really being referred to when we talk about a smaller number of jurors being called in than were summoned. But typically, at least in my experience, court summons in a large number of jurors knowing that there are people who are going to be excused for one of the permissible reasons in the statute, and there's no indication that isn't precisely what happened in this case. Now, other areas that were brought up were irregularities on the face of questionnaires, specifically numerical information in the upper left-hand corner that was referred to. Again, that information is not required by the statute. There is nothing in the statute that requires a jury commissioner or a clerk to maintain that type of information. And in fact, if the court were to go to the Idaho Supreme Court website and pull the standard jury questionnaire form, none of that information is included on the form. So whether or not that was an internal issue with the clerk's office or the jury commissioner's office, it is certainly not an issue that would require the court to stop this case invoking 2-213. There were allegations about the way that some of these jurors filled out questionnaires. Again, I don't dispute that the jury questionnaires require certain information to be filled out, but it's not, the act doesn't compel jurors to do that or govern the jurors' behavior in doing that. Instead, the act sets forth the remedial steps that the court or clerk's office or jury commissioner's office is supposed to take when that occurs, and they haven't even made that allegation, nor have they asserted that there's anything in the other materials that give them reason to think that there were issues related to one specific juror who failed to check one of the boxes. Now, the other thing that came up in that motion was that there were jurors that the presiding judge, I believe, had praised some of the jurors for a handful of jurors who agreed to serve despite having other obligations. Again, Your Honor, this is really, really stretching the purpose of the act. This conduct is not forbidden by the act. The act does not prevent a presiding judge from thanking jurors for their service. This motion to stay should be denied. There certainly has not been a substantial failure to comply that has been alleged. Arguably, there hasn't even been a failure to comply to the extent that these allegations deal with things outside of the act. We would ask the court to deny this motion.
Yes, Your Honor. Idaho Code 2-208 requires that there be a public drawing for the grand jury. The jury commissioner is charged with having a random list of jurors and calling the jurors from them. I don't know what other information I could be in possession of at this point without an evidentiary hearing, other than the irregularity in the upper left corner of the grand juror questionnaires, all of them, all 32 of them. There are differences between those. I think that is probably how those are tracked, the random nature of those are tracked, but I don't know. There's not a mechanism where I am going to have that unless we have an evidentiary hearing. So pursuant to the statute, that raises a question. Your Honor, further in the statute, the number of jurors was required and ordered by the court to be 45. All of the things that don't fit into the statute, the juror bias, the judge's impact on freezing jurors for staying that had other issues that were pressing them, those are examples of why it matters. We're not saying that there's a statutory subpart that says those very things. We're saying there was a court order for 45. There was a failure. There were 32 calls, and we think the court should find out why and if it matters. Your Honor, we provided examples of why it matters. Your Honor, in Idaho Code 2208 subtext section 3, the missing information, I believe that the form is supposed to be sent back to the juror. I don't know if that was done. I can tell you that there's things that are wrong on the face of those forms, and there's not an indication if they were sent back, if they were ignored. There's a process there, and if it's not done, that's a substantial failure. We're asking the court to please stay the proceedings so that we can look into these matters.
Thank you. So, one of the things that I'm thinking about is just how short the time is we have right now. I looked at the affidavit. It's pretty vague, I have to say. I looked at the case law, I looked at the statute, and I know that your team has looked over the transcripts and materials. I know that I believe Mr. Thompson was there for this period of time. They don't have that advantage of knowing what happened. I wasn't there. I I haven't looked at this material. And based on what has been presented, I'm not persuaded that there is a substantial failure to comply with this chapter. I just don't see it. I think these are sort of typical things that we see all the time with jurors. It's not unusual for a number of jurors that we ask to show up don't show up. I don't think it's that unusual. And so some of the concerns that Mr. Kohberger cites very well could have been corrected with some questions. I don't know. So I'm going to deny the motion. And connecting to the earlier sort of order to allow the defense to get the transcripts, give you time to get the transcripts, to get the materials to the grand jury. I think that that purpose has been satisfied. That's the reason I ordered that in the first place, to give you all a chance to look at what actually happened before the grand jury. So again, I'm not, at this point, not satisfied with the standard finding a substantial failure to comply with the act. I'm going to roll back the original stay, and I'm putting in quotes because it wasn't a stay under statute. It was just my idea to try to give the defense an opportunity to be able to file such a motion to actually stay under the statute. I don't think this reaches that level. So I'm going to deny the request to stay the proceedings under Idaho Code 2-213, subsection 2, and I'm going to roll back my prior order. As far as I'm concerned, we're starting the trial October 2nd. We're going to start with jury selection the week before. That was going to take a long time. Right now, I think we have trying to bring in 1,000 potential jurors. At this point, I'm not even sure that's it. But that's what we're at. Okay, so next motion, I believe, is the state's motion to compel notice of defense of alibi.
Yes, sir. Thank you. And Judge, since filing of our motion looking at the defense's response, it looks like we've made a little bit of progress. The defendant has at least, Mr. Kohberger has at least now stated that his alibi is he was out driving around that night. We knew that already. And if that's his alibi, so be it. What the defendant has still failed to do is to comply with Idaho Code 19-519 and Idaho Court Rule 12.1 that specifically requires a defendant to provide, identify the names of witnesses who will be called to support the alibi along with their addresses. The defendant has only said, well, I may do that, or I may call witnesses, or I'll do it through cross-examination. And of course, I have the right to testify on my own behalf. We don't question that. At this late date, I do not believe it is possible, even if the defense were to provide a list of the names of witnesses and addresses today, that with everything else that needs to be done leading up to a week before October 2nd, that there's any way that the state could reasonably be expected to respond with the, as contemplated by the ruling statute. So the state's position at this point is we will accept what the defendant has said, that he was driving around, although he should specify where he was driving. If he's not going to call anybody else, if he's not going to offer evidence to anybody other than himself, then that's none of our business. So we're willing to accept that with an order from this court prohibiting the defense from offering third-party evidence, whether by direct or cross-examination, in support of the defendant's claimed alibi. If he wants to testify to that, that's his prerogative. But at this point, it's too late for the defense to comply with the statute and identify specifically people and their addresses who testify. So that's where we stand now, Judge. Thank you.
Ms. Taylor?
It's me, Judge.
All right.
Your Honor, we provided to the prosecutor what we can provide to the prosecutor and more. I think that Mr. Thompson's right. We don't have to tell the prosecutor if Bryan's going to testify or what Bryan needs to say. We have indicated that that it's possible that we would have additional things that might come out through expert testimony and cross-examining the state's expert. I don't have documentation to give to the state today. I am not going to go into any more of that at this moment. I understand we're not October 2nd. I definitely understand that, and I've heard everybody's thoughts and concerns. I get that. But I mean, this is what we have, and when there's more, I will tell you.
Your Honor, with all respect, that is exactly what the rule and the statute are designed to prohibit. As the U.S. Supreme Court observed in Taylor v. Williams, the ease with which an alibi can be fabricated. The defense is waiting to gather up evidence, seeing what they can fabricate to match that evidence. Say, oh, by the way, here's an alibi now. That is specifically what's prohibited by the statute, by the rule, by the comments of the U.S. Supreme Court on Williams v. Florida. Trials are not yet a poker game where players enjoy an absolute right to always conceal their cards until played. And that's what's going on here. That's why the rule exists. You just need to cut it off and we'll move forward. The defendant can testify to his own alibi if that's what he wants to do. But it violates the rule, the statute, and the rights of the state to a fair trial to allow third-party evidence, whether by direct or cross.
Well, the way I understand this is, and this is in the so-called alibi, not really an alibi, but, quote, he was out driving during the late night and early morning hours of November 12th to 13th, 2022. So what I'm going to do, because the next motion is for a scheduling order, I'm going to address this in terms of the demo, and we'll see how that goes. Right now, that is as far as Mr. Kohberger wants to go with regard to alibi, and that's fine. But if there is going to be, Ms. Taylor, you suggested that there might be some witnesses, then offer not a certain date, certainly before trial. I read the Albert case, which was interesting because there were witnesses. The judge refused to allow them to testify, and that case. Yeah, I don't. Maybe it was then Perez. That was 2021. That was a court of appeals, and they said not a lot. So, Ms. Taylor, you acknowledge that potential risk to your client in the latest response to the request. So, there's some potential balance. prosecution in the United States. All right, so I think that takes care of that for now. So I'm going to give you deadlines. So I think the last motion then, again, this motion to dismiss indictment has been pushed out. We haven't set it yet, but we will talk about that. But there's the motion for scheduling order. Absolutely, we need scheduling order. Okay, I don't dispute that. Didn't do it earlier because we were dealing with other things, thinking possibly this case was going to get pushed out because there were so many issues that we need to discuss. I understand that Mr. Kohberger is anxious to have this student trial. So I'm going to tell you, this is a little bit of a reality check. I'm just going to tell you what the schedule is. Okay? And I'll issue an order so you'll be able to see it. So 6 weeks, about 6 weeks away from trial. And I'm going off of Mr. Thompson's motion, and maybe added a couple of things, but deadlines for completion of discovery, September 1st. Deadlines for expert disclosures under Rule 16b7 and C4, September 8th. If there is an actual alibi, then it's required under Rule 12-1 and 19-519, September 8th. Deadlines for pretrial motions, including motions in limine, motions related to the death penalty, and other motions under Rule 12b. And I'm going to say also, if your client, Ms. Taylor, decides to waive speedy trial, I'm going to have a deadline of September 8th. Because there's going to be a lot of work between now and October 2nd, and if that is in fact what's going to happen, then we want to have that to happen earlier than later. Deadlines for responses to the motions, September 15th. Deadlines for proposed jury questionnaires, September 15th. Deadlines for proposed witnesses under Rules 16b6 and C3, September 15th. Deadline for any Rule 404b notices, September 15th. We'll hear all the motions, and I'll clear out the whole day, September 22nd at 10 a.m. I'll call it first steps for death penalty qualified jury selection. I'm carving out September 25, 26, and 27. I don't know if that's enough. We'll see. Final pretrial conference, September 29 at 10 a.m. Trial, October 2nd, starting 8:30 through November 17th. This is a tight schedule, you all know it, but we can do it. That's what everybody wants. I'm up for it. But I'm going to clear out the deck for September. And so there may be other things that come up, including if you want to set a hearing on the motion to dismiss the indictment at this point.
Your Honor, we should set that for hearing, but we have an additional motion to dismiss the grand jury indictment for various different grounds. It hasn't been Sometime probably 2 to 3 weeks. Yeah.
3 weeks, oh, here we go. Two to three, not next week. We'll do it next week.
I cannot do it. Do it week after.
I am booked that week because I'm trying to clear everything out. Okay, so well, actually, we could do it the afternoon of September 1st because I had that at one point. We were going to have it. September 1st, that's a Friday. Say 1 o'clock.
Judge, we're going to need time to respond to whatever other motions they're going to file. So we're going to need a due date for them with a reasonable amount of time for us to respond to any additional grand jury attacks.
When will you need, when can you file?
I think we can file it probably by midweek,
Midweek,
Wednesday.
okay, August 23rd,
Yes.
okay. Let's say August 29th for a response, is that, I mean, we're on a tight schedule.
Understood.
Does that work? And then we can still do September 1?
I'm wondering if maybe it would be wise to put it out all. We've got a bunch of things going on the 8th. Just do it on the 8th. So, Mr. Nye isn't available. So if it's about the grand jury, we need Mr. Nye.
He's not available, what, September 8th or
Yeah,
September
what I was
1?
proposing.
Your Honor, 6th, 7th, and 8th, I'm not available. I think we could probably do it. I guess my question is just, how long is this, not like 400 pages? If it's one of those, I'm not going to be able to respond in a week, so.
Oh, please do not give me a motion of 400 pages, please. I don't have time.
It's not 400 pages, Your Honor.
What is it?
Not 400 pages.
Okay.
Well, yeah, that may be kind of an overstatement. The motions that we've seen on some of these issues in other jurisdictions are multiple pages, as the court can see from the one that's pending. Dozens of pages of attachments of taking us back into ancient history. Realistically, the court's got the same amount of time as we do to try to digest all that, plus we have to respond.
I've read every single word.
Yes, sir, we've been there.
So, can we do it on September 1st? I'd like to clear it out. Hey, if I'm going to dismiss the indictment, I mean, I think everybody should know that pretty soon. Also, if I deny it, everybody should know that pretty soon.
And I think our concern, Your Honor, is just, we're talking about a potentially very lengthy brief being filed sometime next week and then a deadline the following Tuesday. I think that the brief deadline, I think, is potentially more concerning than the hearing date.
Okay. So you want a little more time to respond?
Well, I think they should have a deadline and then perhaps at least a week for us to
Well,
respond.
their deadline is August 23rd.
23rd, okay.
Yeah. So,
If we,
I'm trying to accommodate everybody, trying to make everybody happy.
understood, Your Honor, if we could have till the 30th, then I'll just, whatever it is, I'll respond to it in 7 days.
Okay. So you could respond by August 3rd.
I'll do my very best, yes.
Okay. You can't ask more than that. You say you're not available September 6th, 7th, and 8th?
Correct, so if we respond by the 30th, and then we can do the hearing 2 days later on the
We'll make it
1st.
work, Judge. I was planning to be out, but I'll change that. That's not a problem. I'm
Okay.
clearing my calendar.
I'll make it work. 1 o'clock, September 1st?
Yes, sir.
Okay. Keep the lines of communication open, okay? Be respectful to each other, and maybe some of this can be ironed out.
And just to clarify, Judge, on the September 1st deadline for discovery, that includes also all litigation and sentencing evidence. Is that correct? Because it's all one and the same. Once we get going to trial, there's not going to be another break.
Well,
I just want to make sure that the defense and we are clear that that's the line being drawn, because I don't want to get balled up in some
Right.
after the fact saying, oh, well, for purposes of sentencing, we want to call this expert and this mental health person and these family friends and all that sort of stuff. That's not going to be appropriate post-time trial starts.
well, figure out, I think this is what was discussed when we decided October 2nd, is that the trial would be 4 weeks, and then the sentencing would be 2 weeks if he's found guilty. Is that what you estimated, Ms. Taylor?
I believe so.
All right. So during that period of trial, I mean, there's a, I see a whole bunch of lawyers here. Maybe that's something that could be done. We wouldn't have to do that by September 1st.
With all respect, I don't think that's realistic, Judge. This case is complicated. I think it's going to absorb the efforts of all the attorneys that are standing before you right now, just on the issue of guilt. And the state, of course, needs to have time to react. The defense is going to disclose sentencing experts. Is going to disclose possible things about background, mental condition, those sorts of things. Those are complicated, lengthy endeavors for us to respond to, including the possibility of having to retain other experts to rebut whatever the defense Mr. Kohberger wants to offer. And I think if we're realistic about this timeline, we need to suck it up and be realistic about everything. That includes the defense's obligations.
Your Honor, I don't have a comment, of course. I would have a question about rebuttal witnesses for the state, rebuttal experts for the state might call. Disclosures, but I understand what Mr. Thompson's saying. Litigation is a huge complicated piece in every single capital.
I understand too. And I have no idea where you are.
Busily working, Your Honor, very busily working.
I would suggest that maybe there could be a little more time for that. Maybe make a deadline for sentencing, mitigation, all that. Make that September 15th. Because there's going to be a lot to put together by September 1st. That's just 2 more weeks.
2 more weeks, but it's 50% of the time, less than 50% of the time before we're going to be in this courtroom picking a jury, and we don't have time to work on anything else. And, and once we get disclosure on their experts, we're going to have to disclose our rebuttal.
Yes.
And maybe we need to put that date in there. If we make all the discovery, including mitigation discovery, due by the 1st, then Your Honor could have a date for rebuttal a reasonable time after that and still before trial.
So witnesses, that deadline is September 15th, is that what I said?
No, discovery, well, let's see. Let me look. Witness is September 15th, discovery by September 1st. And so if there are reports from experts, from examinations, mitigation studies and that sort of thing, those would have to all be by September 1st.
Your Honor, you made September 8th, the experts,
Yeah.
along with several other things.
So you could have response to experts on the 15th.
Thank you.
So maybe we need to move up the deadlines for witnesses on the same day, lay witnesses, on September 8th with response by September 15th. I thought this was so plain. Once you start thinking about it. That's, I'm not even promising it's doable, but it's just what we need to do. I mean, we're going to be working at night. So, here we are. So, and I'm just going to say your sentencing. Information, disclosures, just make it September 15th. We'll have plenty of time to sort that out. Not plenty of time, but we'll have some time to sort that out. And we can talk about all of that on September 22nd. Anything else, Mr. Thompson?
Not right now.
Ms. Taylor?
Your Honor, I wonder if the court might be willing to set a date for a status conference next week. Status conference,
You bet.
maybe on Wednesday. Wednesday happens to be my best day.
Every Wednesday's your best day, or? No, I'm kidding.
Sure.
Uh,
The next one is,
About 1:30 on August 23rd.
that'll work, I'll do that.
Could we do it just a hair later? I have a dentist appointment, which isn't necessarily the most pleasant thing to do, but they're hard to get.
Okay,
And the older I get, the more I feel I'm going to be walking around toothless someday.
you don't have to confess to anything.
Yes, sir.
How about, what time is it?
It's a 1 o'clock appointment at Bearable here in town. I would say, a little bit after 2, I should be free. If you can squeeze that in, Judge.
I have a civil hearing at 3. How about we go to 4?
If that keeps Ms. Taylor in town longer, that would be fine. Or if it's just a status hearing, we could probably do by 2:15, 2:30, and be done by 3. Would you think?
I think it will be very,
It'd be very what?
I think it'll be a quick hearing, so I think to get you ready for your regular docket, and if we work together at 2:15, if Mr. Thompson can make it, we won't keep you from the regular docket.
Well, I just have one case that's not going to take very long. It's set at 3.
We'll be done on it.
Okay, at 2:15?
Yes.
You just want to do it by Zoom? It's a status conference?
I do not. I want it to be in person.
Okay.
If we could have a Zoom link for counsel who are out of the area, that would be fine.
That's fine. Okay. So, Zoom plus in person. Okay, status. 2:15, August 23rd.
Thank you, sir.
Okay. So for sure, we're all on the same page, right? Kind of sarcastic. Okay, anything else, Mr. Thompson?
No, Your Honor. Thank you.
Okay. Ms. Taylor? All right, well, thank you. Thank everybody for your patience. It's been a long day, and it's 5 o'clock, so we are adjourned. Thank you.